I see that you're on the screen, but I'm not sure that Mr. Henry's noticed.
Good afternoon, sir. Can you hear me?
I can.
And may I begin?
Well, I was about to tell you that you weren't yet on my screen, but now you are. But before you begin, can I just say, Mr. Henry, that it is possible that this afternoon's session won't take until 4:30. I would just like to reassure those who are scheduled for tomorrow that I'll stick to the timetable. So if we do finish earlier than 4:30, so be it.
Thank you, sir. Sir, could I outline at the very beginning that I'm going to be, as it were, responding, not in any legal sense, but reflecting upon the magisterial opening that Mr. Beer, King's Counsel, delivered. And I'd like to thank him for the immense care, detail, and effort he and his team have so obviously demonstrated in that opening as counsel to the inquiry. And it was rendered more powerful by Mr. Beer's restrained and sober delivery. And yet, in spite of that, sir, the more one listened, ever and ever more disquieting became the matters he addressed. The United Kingdom is a nation of laws. Equality before the law, indeed our very conception of ourselves as a just society, is founded upon that premise. But as Mr. Beer told his tale, it almost began to seem as if he'd made it up. It was as if we had become a Ruritanian dukedom or principality where undue respect for hierarchy and judicial deference towards an institution had reduced people to serfdom and economic servitude, in which that trusted institution, the Post Office, had taken every advantage, just and unjust, when exercising almost totalitarian control over those it pursued to custody and beyond. Destined, as Tracy Felstead was, to be sent to an adult women's prison even though she was but 19 years old, or as Seema Misra and Janet Skinner were, to incarceration in adult prisons where Seema was only kept alive by the knowledge that she was pregnant, and where Janet refused to see her children because she could not bear to let them have a memory, that indelible image of seeing her across a Formica top table wearing prison scrubs. But the injustice did not end there. It went beyond that, reducing its victims to destitution by bankruptcy or criminal confiscation. For those in the dock, and also for society itself, the depressing truth, which, sir, you will not find difficult to establish, was that the Post Office strictly controlled the flow of information and denied exculpatory material to those it had accused. In civil matters, it deprived those it pursued of the means to bring counterclaims or defend unmeritorious claims that had been brought against them. That it was enabled to do so lay in part in the naive belief that computer evidence is reliable and that the Post Office could itself be trusted. That a multinational household name, Fujitsu, was also acting with integrity. How wrong those assumptions were. The Post Office scandal reveals that notwithstanding the legal burden of proof that lay upon it, again and again it successfully shifted the evidential or tactical burden upon its innocent victims. that they were to establish, as it were, that the computer was not working reliably at the relevant time. And a defendant is utterly unable to discharge that burden unless they coalesce and act as a concerted group. And I refer, of course, to the Horizon litigation before Mr. Justice Fraser. But in criminal courts up and down the country, there was a huge disparity of resources and obviously a disparity of information. And this is starkly revealed by the cases of Lee Castleton, one of the core participants that together with Miss Page I am honoured to represent, and Mrs. Misra. In both cases, as Mr. Paul Marshall has said in his evidence to the House of Commons back in July 2020, civil and criminal respectively, both Mr. Castleton and Mrs. Misra positively averred that they believed the problems they had experienced, accounting shortfalls at their Horizon terminals, might lie with the computer system. In neither case was the Post Office required by Judge Havery, Queen's Counsel, as was, or Judge Stewart, to prove affirmatively that the Horizon system was working properly, reliably, at the relevant time. Had the Post Office in either case been required to prove that the Horizon system was working reliably, it could not have done so. That is so as a necessary consequence of the factual findings of Mr. Justice Fraser. He found that from its introduction, the Horizon system was A, unreliable, and B, apt to generate accounting errors and shortfalls of the kind alleged in the Bates Group litigation, and as had been alleged by Mr. Castleton in 2006 and Mrs. Misra in 2010. And you'll be familiar, I'm sure, sir, with that extract from Mr. Marshall's statement. One never expected or imagined that Pol could act in this way. One had a right to expect far more, much, much more from a state institution. If its brutal policy of raw claw civil litigation wasn't bad enough, how on earth had an agent of the state, a government dominion as it were, decided to prosecute hundreds of sub-postmasters after it had realized, indeed knew, that Horizon wasn't safe? Why? Apparently not content with aggressive old-school civil litigation tactics, had it deliberately chosen to harrow, indeed terrorize, loyal sub-postmasters, criminalizing hundreds of innocent people. How could it have countenanced exposing so many of these loyal, blameless, already broken victims to the risk of being put behind bars? Such callousness reveals a corporate mentality that branded sub-postmasters as a liability rather than Pol's biggest asset. The sub-postmasters were no more than a number, equivalent to the phantom balance they supposedly owed, a disposable commodity, a debt to be pursued, an example to be made of. So it is, sir, and you know this already, but it is your imperative duty to examine Pol's conduct of litigation from the County Court to the High Court and the Magistrates' Court to the Court of Appeal, Criminal Division. This requires the investigation to discern not simply the unjustified faith in Horizon and the origin of that false belief, but to establish when that hardened into brutal realpolitik, the ends justifying the means, that crumbling, corrupt IT system had to be defended at all costs. The question of the Post Office as a private prosecutor will no doubt, of course, be central to your considerations. The Post Office failed, except in one instance, in all its responsibilities as a private prosecutor. First, as an investigator, it failed to investigate. It boorishly and oppressively went all out for a confession. Witness how it treated Sir Nicola Arch, Tracy Felstead, Seema Misra, and Janet Skinner. Each one was hectored, bullied, stigmatized as a thief. This wasn't investigative and impartial interviewing, but an interrogation. And when it couldn't browbeat a confession, it then, from the very beginning, negligently failed, indeed refused to investigate the defence raised by those sub-postmasters that Horizon was to blame. But negligence, at some point, went further into active, unforgivable misfeasance. And in this it was aided and enabled by Fujitsu. Witness the shameful conduct as related by Miss Felstead in her evidence before you, sir, and Mr. Turner, her then expert, who was told at court that it required a payment of £20,000 in order for the disclosure to be produced. And you will remember counsel to the inquiry, Mr. Beer King's counsel, asking her those questions earlier, I think it was in February this year, or March, when that was revealed. And subsequently, we have tried to contact Mr. Turner, but unfortunately we believe that he has died. But he did submit a note when he became aware of this, and he was struck at the time by the injustice she suffered. And it remains a mystery why he was not called at her trial, but we will endeavour to ensure that you have an appropriate answer where that is concerned. But it brings me now to the second role that Pol had as a litigator. And as a litigator, it behaved atrociously. It did not simply fail to discharge its duty of disclosure, but deliberately disregarded it and suppressed it, playing hazard with the lives of those it prosecuted. It therefore connived at securing wrongful convictions. Worse than that, it adhered to a practice that the Court of Appeal deprecated as long ago as 1971, when the Court of Appeal had adjured the Post Office to abandon charging both theft and false accounting. And even though that guidance was obiter, it was plainly not followed. And, sir, you will no doubt recall the case of the Crown and Eden, 55 criminal appeal reports, 193 for the 1971, in which the practice of the Post Office charging both theft and false accounting received the following observations, if I can put that in inverted commas, by Lord Justice Sachs. And he stated, "It seems to this court to be rather odd that two counts, theft and false accounting, should be put in parallel setting if it is the object of the prosecution to secure a conviction on the first only if the second is proved, or on the second only if the first is proved. There would seem in those circumstances but little point in putting two separate counts. It would be better in future that the prosecution should make up its mind as to whether or not it really wants a conviction on a count for false accounting only if theft is proved. If so, reliance should be placed on one count only. On the other hand, there may be cases when it is wise to have a count for false accounting, where, for example, where, for instance, a temporary gain could be the object of the dishonest act." Well, as stated, sir, of course, that is obiter, and thus the reference to adding a count to address a temporary gain is likewise obiter. But in this case, there was no temporary gain. In this case, this was the sub-postmasters being tormented by false results provided by a defective system, Horizon, and sub-postmasters accepting balances simply in order to continue to trade. And in those circumstances, sir, which prosecuting authority would really wish to proceed against them? Would it really be necessary if evidentially, as we now know, the evidential test was clearly suspect with this nascent and evolving system subject to so many bugs, errors, and defects? And in any event, these people having candidly explained their difficulties and have sometimes been advised, as you learnt from my learned friend's opening statement as counsel to the inquiry, to just balance the books, advice given by the helpline. How could it possibly be right to prosecute them? The Post Office, however, was not looking at this as an independent prosecutor. And that brings me to the third point. The Post Office as witness, aided by Fujitsu. It was guilty of the most egregious wrongdoing. Aided and abetted by Fujitsu, of course, in relation to expert evidence. You, sir, will remember the decision of Mr. Justice Creswell in the Icarian Reefer, the concerns over abuses in both civil and criminal courts as to expert evidence, the civil and criminal procedure rules which were drafted in response to that, and in particular, so far as the criminal domain is concerned, formerly Part 33, but now Criminal Procedure Rule 19. It's a very serious business. In the late 1980s, early 1990s, in a series of landmark appeals, the case of Judith Ward, the Birmingham Six, the disgraceful misconduct of experts came to light. The idea that the expert was somehow independent and impartial was in fact shown to be a lie, hence the necessity of the Royal Commission, and hence the very real importance that our system of justice is not corrupted by false evidence. But unfortunately, sir, because of the desire to defend Horizon at whatever cost, with the raw material for that being human misery, expert evidence was abused time and again. And you will see that in Lee Castleton, in the evidence of Miss Hobbs, and you will see that in the case of Mrs. Misra, in the evidence of Dr. Jenkins. Which brings me to the fourth point. Poll as a Minister of Justice. It could not be trusted to act in accordance with those duties that fell upon it as a Minister of Justice. In particular, objectivity, impartiality, and restraint, as opposed to what Mr. Justice Avery described in the case of Banks as acting as an avenging angel. And so ultimately, Poll only excelled in its role as a querulous, slightly paranoid and vengeful victim. But that was entirely performative. It was never a victim, just as its prey were never criminals. This inquiry, sir, however, must consider more than Poll's role as a private prosecutor. Professor Richard Moorhead, who gave evidence before you on the 8th of November 2021 as an interested party, cogently described the manner in which the law, in whatever jurisdiction, was abused as central, indeed fundamental, to this inquiry. He argued even more important than the software itself. This was because the law created, indeed sanitized, these myriad injustices. He stated, and I quote, "We don't think there can be any argument that Horizon harms directly arose from the way legal work was managed and conducted. People were threatened, sued, fired, and prosecuted via partly or wholly legal work. When Post Office and Horizon in particular came under scrutiny, denials, non-disclosure, and harm visited on the sub-postmasters and the legal work supported, or forgive me, so I'm going to start that again. People were threatened, sued, fired, and prosecuted via partly or wholly legal work. When Post Office and Horizon in particular came under scrutiny, denials, non-disclosure, and harm visited on the postmasters, and the legal work supported or failed to challenge the corporate governance failures that marked this scandal so profoundly. You will be aware that we say that some of that work was probably done incompetently or unethically in our view. Certainly, there are serious questions that need to be looked at. Professor Moorhead opined and was correct in submitting to you, we submit, that you could not get at the truth without analysis of the individual cases. And we pay tribute to the fact that you have heard and encouraged so many of the victims to come before you and speak where they are able to as to the profound suffering they experienced. But Professor Moorhead continued, "We know from the Hamilton and Bates judgments that shortfalls were pursued oppressively, prosecutions were pursued unconscionably, and the safety of those convictions was considered or reviewed, it seems, inadequately. But we do not know how and by whom oppression and unconscionable approaches were put in place. I said, in essence, Horizon is not solely or even mainly a computing scandal. It is also a lawyering scandal, but it is above all a corporate governance scandal." And I return to the individual cases now. And the core participants we represent are paradigms of the evil that was done. Tracy Felstead and Nicola Arch, right at the beginning of this disastrous era in criminal justice, right at the beginning. Lee Castleton, the civil case, heard in December 2006 and January 2007. The precedent, the illustrious scalp that was brandished before anybody else who wanted to challenge the Post Office. They took him to the High Court in London, having failed to appear at the Scarborough County Court and then having had the matter successfully transferred from the High Court Registry in Leeds to the Royal Courts of Justice, pursuing a £25,000 claim, and the costs in connection with it came to £321,000. It is staggering. They bankrupted him. They very nearly destroyed him. He told you, sir, that if he had been a braver man, he would have killed himself. Seema Misra, her case demonstrates every conceivable mischief of non-disclosure, perjury, and oppression. And then finally, Janet Skinner, a paradigm case of an honest woman broken by this discreditable charging practice, particularly since they could not under any circumstances have proven theft, owing to the defects in the system. And she enters a plea, an unequivocal, I suppose, but false plea, because she had been crushed. And there must be, and there are, sir, hundreds just like her. And so therefore, she is vitally important as well, her story, to the issues that you are required to determine. Serious criminal charges emerge from this scandal, we submit. Perjury is one, perverting the course of justice, the vital administration of justice is another, contempt of Parliament quite possibly even another. And so far as legal professional privilege being vitiated, Professor Moorhead stated that evidence of iniquity was in abundance. Evidence of iniquity in abundance. What and how brought Poll to this? What motivated Poll? Was it arrogance, hubris, paranoia that an epidemic or endemic theft and false accounting had suddenly, like a wildfire, burst out at branches up and down the country? Or was it far more sinister than that? The narrative of a computer-driven utopia. And so to serve its own ends, corporate, commercial, political, and reputational, it had to subjugate all those who might challenge it together with Fujitsu, and thus condemn those innocent people into a never-ending dystopian nightmare. Does it come to that? And I mentioned Fujitsu. What about its sidekick? The naked triumph of Fujitsu's commercial interests trampling over the innocent seemed, and still does seem, utterly incredible. As Mr. Beer's opening continued, it was delivered with appropriate pathos for the victims of this tragedy, pathos which never compromised his independence or dispassionate objectivity. And yet a staggeringly surreal element began to emerge at times, sir, from his almost prosaic exposition of the facts. There is no need now to name the great and the good who Mr. Beer mentioned, the don't you know who I ams who then populated the Central Criminal Court in the East and formerly the Supreme Court in the West, with one Essex court almost plumb in the middle. But it seems that the establishment writ large, with all its weight, was brought to bear on the little people. And among the putrid story that emerges are these questions which we now pose for your consideration. How had this country, the oldest democracy in the world, failed so many, approaching somewhere between 800 and 1,000? How had its institutions not merely failed, but had become complicit in tearing up the lives of these decent, law-abiding, entirely innocent victims, those isolated individuals because they thought they were isolated, dare I say ordinary people who suffered so much and still suffer to this day. They can be counted in their hundreds. They may be the so-called ordinary people, but their lives, as you recognize, sir, are precious and have value. They're not ennobled. No accolades, letters, or chivalric insignia follow their names, but extraordinary wrongs were done to them, and those wrongs still continue. The causes of their suffering must be arrived at by you, sir, root and branch. Your root cause analysis will be multi-systemic and multifactorial, and you will only overcome the many obstacles you face if, in accordance with the hope you fervently expressed, and fervent was the actual word you used, that you might receive cooperation from all parties. You expressed that wish on the 8th of November 2021, but only by adherence to candour and transparency by all the core participants, acting in good faith and with goodwill, shall you be enabled to arrive at a sound conclusion. And in doing so, in reaching your conclusions, the accountability of each branch of government that allowed this to happen, indeed, perhaps doomed it from its inception, must also be determined. And so I come to that aspect. A common theme of failed public sector IT projects, and of course this was a public PFI IT project, is the lack of proper governance and oversight by government. And Horizon was no exception. But what took the troubled history of Horizon's procurement out of the commonplace, such as the viability of the project itself, was diplomatic pressure, expedient responses to threats of litigation, and continuing internecine struggles between government departments. It now seems clear that the project had objectively failed before it was inflicted on post office branches and Crown offices nationwide. We submit that because, of course, it did not meet the standards agreed, and the functions specified were subject to inherent vulnerabilities. The writing was on the wall and predictable by the burgeoning costs, repeated delays, and failures to meet completion deadlines. And it is understood, and this is a matter, no doubt, upon which Mr. Page will be able to assist you, and also other evidence that you will hear, that projects with long development timeframes have a very high probability of failure. And in fairness to Fujitsu, repeated alterations to the specification by government exacerbated the problem of delivering this mammoth, so oftentimes repurposed project on time. There were undoubtedly system failures, the bugs, errors, and defects that meant that Horizon did not perform as expected and was subject to unpredictable, at times unknown, in other words, latent, and entirely unforeseen, so far as the sub-postmasters were concerned, errors. In blunt terms, it didn't work properly. As Hume said, the fact that a match can be, the fact that 19 matches ignite is no proof that the 20th shall. David Hume. And as Mr. Justice Fraser outlined so clearly in his judgment, the fact that it works most of the time does not mean to say it works all of the time. And then, of course, from the very beginning, there was a failure to ensure that the needs and expectations of the sub-postmasters were met, considered, or even taken into account. The arrogance is breathtaking. The sub-postmasters, the end users, were not front and center of the development process. How could they? If they were to find out that they were to lose control of balancing out their accounts, that they would have to bow before the computer and surrender their control, no doubt there would have been uproar. How can a program, we ask, which requires a user manual of more than 800 pages, be remotely practical? Doesn't that speak for itself? What budget was allocated for training? How likely was the rollout going to be fit for purpose, given the lack of staff to implement so-called user awareness sessions that were brief and inadequate? Was this euphemism for training another ominous sign? Was it destined to fail? How convenient. Blame it all on the sub-postmasters as user error. We submit that rolling Horizon out in such circumstances was the height of folly. It was an act of political and reputational expedience. Instead of listening to its frontline staff and sub-postmasters, Pol and Fujitsu decided, we suggest at some point, sir, to enter into a pact by which sub-postmasters were to blame. They were to be sued or prosecuted on the grounds that Horizon was infallible. It was a policy founded on a ruthless disregard for the facts, motivated by mutual self-interest and political expediency. It was easier to blame the sub-postmasters than to give the most remote credence to their concerns. The alternative was devastating. They would have had to have gone back to the drawing board, ripped it all up, and started again. So Pol's corporate governance and how it came to weaponize civil and criminal litigation must be examined by you, sir, in the context of who knew what and when. There are clues, however. Clues can be discerned from, of course, evidence that still exists, evidence that was destroyed, and matters that never, ever existed because nobody put their minds to it. But generically, an effective business must have robust internal controls to identify deficiencies in the IT system that it had to work with. These management systems would necessarily involve ensuring that problems, if unresolved, would be escalated to the senior management committees and ultimately the board. And senior management committees with the board's oversight would then properly engage in order to rectify these defects, supervising those delegated to resolve such issues. Senior management committees with the board's oversight would also engage with the corresponding management of the third-party IT provider, in other words, Fujitsu. Had such structures existed, and surely they ought to have been in place, it is difficult to imagine how anyone at Pol and Fujitsu could have been unaware of the crisis engulfing the innocent. Now, sir, prophecy, however honest, is generally a poor substitute for experience. Miss Page and I nevertheless predict that the corporates in this case, and perhaps their former directors and officers, may well follow a studied and studiously well-rehearsed routine that you, given your very considerable experience, will be astute to. Leaving aside equivocation and casuistry, because one mustn't prejudge, but one can easily see a line taken upon reliance on the faults of others, rationalizations concerning almost Byzantine lines of command, lack of coordination and communication between divisions and departments and the like. If only we'd known, if only we'd been told. We trust, sir, that you will see this for what it is, because this is the governance issue that Professor Moorhead powerfully alluded to. It was incumbent upon the board and senior management of Fujitsu and Pol, indeed government, to take ownership of this burgeoning crisis, to embrace accountability, to ask the difficult questions. And had they asked those very necessary questions, then there would have been no need for this inquiry to do so. But now, sir, you must ask and answer those difficult questions in their stead, because of the appalling consequences of their failure to do so, because of the catastrophic impact upon those that were scapegoated. Those who constituted the directing mind and will of the corporates may rest the blame on middle management or seek to pass responsibility to their internal legal department. And ultimately, given what Mr. Beer King's counsel has already alluded to, point the finger at each other and government in a sort of three-way good, the bad, and the ugly Mexican standoff. We suggest to you, sir, however, that this is a self-defeating strategy. They had a fiduciary duty. They had a duty to inquire. And of course, they had a duty of care towards the sub-postmasters. How Pol blithely accepted and regarded as truth that well over 700 staff had turned base after years of loyal and honest service, founded largely or mainly upon a defective computer system, Horizon, ought to have been documented and explained. It ought, sir, to have been a red flag. Were any concerns or warnings expressed at any stage, citing the manifest improbability of all these worthy individuals becoming criminal? What about the help desk? And then returning to head legal office, why was there no central file of those who had maintained that Horizon was the cause of the shortfall or deficiency? Would that not have been assiduously kept, a register of each dispute with the litany of complaints against Horizon? But apparently not so. And again, one has to ask whether this may have been a deliberate policy so that the picture emerging, the mosaic we allude to in our opening statement, with each little shard or fragment being a broken life, wrongly prosecuted or sued, that they didn't want that. They simply wanted chaos without an index. It all comes to their own management of data. And if you do not wish to be briefed, and if you do not ensure that there are systems in place that you can be properly briefed, then you have to wonder if that is by accident or design. What we submit to you, sir, is that the more these responsibilities or duties of accountability are evaded, the more untenable Pol's and Fujitsu's position will become. If there were hermetically sealed boxes, if left did not know what right was doing, if a need-to-know divide-and-conquer culture existed in those institutions, this is no excuse. The tone and structure, the apparatus of governance and accountability is set by the senior management and comes from the top, not the bottom. If there were rigidly hierarchical or labyrinthine structures impeding communications that being left uncorrected may reveal a desire to exploit the ulterior advantages that always come with such over-complex and ineffective corporate architecture, the means by which those in authority are enabled to say, we did not know, to make plausible denials. Ultimately, however, the buck should stop with those at the top. To the cynical, however, the best form of reinsurance is to retain the service of the most eminent silks, even a retired justice of the Supreme Court. Their once privileged position, pun intended, may become distinctly uncomfortable given the tight corner in which Pol now finds itself, together with its former senior management. The legal advice Pol happily once received may now fall within the crosshairs. One cannot say for sure, especially after so many years have passed, and especially with the expression of contrition at the beginning of Pol's opening statement, But Paul might now choose to blame those who were prepared professionally to stand on their heads and perform cartwheels for them, ranging from panel firms who prosecuted to those august persons Mr. Beer, King's Counsel, mentioned. The Post Office, of course, may double down, but it would not be surprising were they to repudiate with the utmost sincerity the advice they had once received, whether to strictly control information being provided to Mrs. Seema Misra, removing her eligibility along with Miss Felsted from the mediation process with the intention of depriving her of information which was critical not only to her appeal but everyone else's, or in the civil proceedings, so absurd as the effrontery now seems, to seek to recuse the one judge who seemed determined to demand answers from their counsel, trial counsel, who himself, it appears, seemed to be oblivious of the recusal application that was about to take place, sir, when Lord Grabbanner entered the court. So it could be this position, and again this has been alluded to by Professor Moorhead, that the executives will blame the lawyers, and no doubt the lawyers will blame the executives. And so you are confronted, I respectfully submit, with that classic problem that was identified so long ago by the then Mr. Justice Leggett in Guestmin and Credit Suisse, which is that legal proceedings, and although this is not a legal proceeding, the same inherent biases will exist, tend to distort the memory. And so therefore you're forced to go to the contemporaneous documents. But beware, because you will have already noted from what was put up on the screen yesterday that some of those contemporaneous documents are Janus-faced. They make a statement of principle and then derogate from the statement of principle thereafter. So, as libel lawyers or defamation specialists frequently say, don't just look at the headline. The headline may sound the right tone, whereas the rest of the advice or review may not. And that brings me, sir, to three matters before I will very briefly go through the submissions that we have submitted already. Disclosure. Your disclosure protocol of the 28th of July 2021 is, I respectfully submit, inextricably bound up with the fervent hope you expressed in November of last year. And the disclosure protocol, which you're very familiar with, sir, stated, wherever possible, the Chair intends to rely on voluntary cooperation for production to the inquiry of the documents he considers necessary to fulfil his terms of reference. The Chair will normally make a request for voluntary production of documents by means of a letter, etc., etc. The Chair expects that all parties to whom a request of this kind is addressed will cooperate with the inquiry and will provide all relevant material without the need for him to exercise his powers of compulsion of documents or evidence. And then I omit words. Providers of documents, including legal representatives, should provide documents requested by the Chair, together with any other documents they consider to be relevant to the inquiry's terms of reference, without delay and within the time limits specified by the inquiry in any relevant request. PODs are expected to undertake comprehensive, thorough and rigorous searches in response to the request of documents. And I need not say anything further. Well, unfortunately, sir, that was a bit of a dead letter, and we respect the decision you made on Tuesday of this week, and I don't seek in any way to go behind it. I fully understand the fact that you did not wish to lose momentum. But the fact of the matter is, without disclosure, justice is smothered, and when there is non-disclosure, injustice flourishes. Now, none of Mr. Altman's documents, advices, or reviews were disclosed in the criminal appeals. The existence of his 2013 review was known, but not disclosed. And it is jaw-dropping when one considers Pol 406485, and I will not ask for any document to be put up on screen, sir, Mr. Altman's consultation, which took place on the 9th of September 2013. Jaw-dropping. And that is, I regret to submit, one of those Janus-faced documents. And 6 years later, his advice on settlement, Pol 406401. And again, hair-raising, paragraphs 19 to 22, 25, 27, paragraph 31, 17th of June 2019. Utterly inimical to the very grave and onerous responsibility on the Post Office as prosecutor that by that time it knew, or at the very, very least suspected, that innocent people had either gone to prison or had been criminalized for nothing. And in fact, really, that ought to have been clear as far back as the Clark advice and the shredding advice. It ought to have been clear. And what the Post Office ought to have done was to have self-reported to the CCRC, and for good measure, it probably ought to have written to every court in which it had brought a prosecution, and it ought to have perhaps even self-referred to the DPP. But it did not. There was raw claw litigation in both the civil and the criminal litigation at appellate level. And the ineluctable conclusion we submit is it was because they wanted to suppress, they wanted to smother the truth from ever getting out. They wanted to manage things. Now, we have to return to the issue of knowledge. And I would now be very grateful, sir, if you could just note that the solicitor of the inquiry wrote to those who instruct Miss Page and myself on the 27th of September 2022, because we, perhaps out of an abundance of caution, and perhaps unnecessarily, for which I ask your forgiveness, had written to the solicitor of the inquiry expressing concerns about the terms of reference. And the solicitor of the inquiry wrote back in these terms. And it states, in relation to the matter set out in paragraphs 1A and 1B of your submissions, was evidence as to the unreliability of Horizon hidden from public scrutiny? And if so, who was responsible for doing so? I would draw your attention to the following issues. Issue 49. Your issue 49, sir. What information and knowledge did Post Office Limited, Royal Mail Group Limited, Fujitsu Services Limited, the National Federation of Sub-Postmasters, the Communication Workers Union, UK Government Investments, and the government have about the following facts and matters during the relevant period? Read with A, the existence and extent of bugs, errors, and defects in the Horizon IT system. B, the ability of such bugs, errors, and defects to cause apparent discrepancies or shortfalls in branch accounts. C, the ability of such bugs, errors, and defects to undermine the reliability of the Horizon IT system accurately to process and to record transactions. D, the extent to which apparent discrepancies or shortfalls arose in branch accounts as a result of bugs, errors, and defects in the Horizon IT system. And then, continuing with our point, the non-disclosure by Royal Mail Group Limited and Post Office Limited of the existence of problems with and/or concerns about the reliability of Horizon when bringing criminal proceedings against persons alleged to be responsible for those shortfalls. And we were then directed to issues 50, 51, 52, and 59, namely at what level within the organisations named at question 49 and the government were these known, when and in what circumstances did they first become aware of these matters, how did their knowledge develop over time, what, if any, steps were taken by the organisations named at question 49 and the government to bring these matters to the attention of sub-postmasters, managers, and assistants. Well, we submit that knowledge, of course, is central. We can start out, of course, with the obvious statement that Fujitsu knew. They knew. They must have known. And if those in senior management did not, there must have been an active policy of Nelsonian blindness, which is, of course, dishonest. And we submit from the very beginning, the Post Office knew enough at the outset to exercise caution and restraint and not proceed as it did against the innocent Nicola Arch and Tracy Felstead. And whilst they may not have known the full picture at the start, they knew enough that it wasn't working. Why do we say that? Because of the difficulties in procurement, delivery, rollout, and training. The rollout, as we submit, was a premature rollout. The defective advice that Mr. Beer took you to, where sub-postmasters were advised to proceed to balance, a sort of force majeure forced upon them by the inherent instability of the system. The advice to sign off an inaccurate account from the helpline beggars belief. What about the training? The training. How on earth, on top of everything else, to get on top of the 819-page training manual? And also the fact that there was no continuity in the training. We know again and again that somebody comes and trains, a glitch, a defect is noticed, and then they never come back. It's almost as if they're not sent back so that there is no continuity of care. And if anybody did take up arms on behalf of a sub-postmaster, they would seem to have been moved on. So we respectfully submit that the helpline as well, all of this must have been fed back. And so the Post Office must have realised at a relatively early stage that the innocent were being put in jeopardy, that the innocent were being potentially broken on a wheel just so that they could pursue what they believed to be a debt. But the Post Office knew subsequently, and we respectfully submit they knew at a deep level that Horizon was subject to these bugs, errors, and defects. But did they reverse their policy of prosecution? No. Did they remediate this appalling injustice? No. They stopped at the beginning of 2014 because they received an advice from Mr. Altman, King's Counsel, which reveals that Mr. Altman cannot have been in the know because he was advising them that they had to have proper protocols in relation to prosecution and also the reliability of Horizon. And as we put in our opening, that could not be done without blowing the lid off what they already knew. And so it was far easier for them, far easier for them to simply stop prosecuting, because the terms upon which Mr. Altman said they could only continue to prosecute satisfactorily and in safety were obviously toxic so far as they were concerned. But that, of course, is far down the line. When did the Post Office know? We will submit that you must concentrate carefully on two matters, sir. The first is the removal of the suspense account, and the second is the pitiless destruction of Lee Castleton. And his witness statement is, of course, WITN 037 301 00. And these matters arose, of course, long before the Computer Weekly document in 2009. Let us deal first of all with the removal of the suspense account, the way in which sub-postmasters could park the discrepancy and, as it were, be allowed to continue to trade. So they wouldn't have to accept the balance, and it could remain, as it were, in abeyance. The document upon which we rely for this is POL 000, and if I'm wrong about that, forgive me, it might be quadruple, but 38870. We know from the properties that it was composed on the 16th of September 2003. And Mr. Nick Wallace, in his book on this scandal, addresses the terrible dilemma that confronted sub-postmasters when it was withdrawn, where they would have to accept Horizon, accept the balances, the shortfalls, or be dismissed. And we respectfully submit that that was a result of the fact that Horizon was unfit for purpose, that debts were building up, and that cupidity, rapacity, call it what you like, on behalf of the Post Office triumphed over justice to its loyal sub-postmasters. The second thing, of course, is Mr. Lee Castleton. And Mr. Lee Castleton, his story is unutterably tragic. This is far more than a legal injustice. This destroys people's mental, physical health, takes away their good name. They're branded as a thief. Their daughter gets gobbed at in the street. Mucus, phlegm, saliva. Mr. Castleton told me she had beautiful long hair, and she would come back having been abused that her father was a thief, with spit and phlegm in her hair. The Post Office needed a precedent, and as I've said, they brandished his story, his fate, before others to deter. He was, as I've already submitted, an illustrious scalp. And a witness called in the case to give evidence of the Horizon system was Miss Anne Chambers, a systems specialist employed by Fujitsu. Her evidence was that she found no evidence of any problem. Judge Havery, Queen's Counsel, was impressed by her. He described her as, quotation, clear, knowledgeable, and a reliable witness. That was not, however, Mr. Justice Fraser's conclusion. And this is what Mr. Justice Fraser stated. At least Anne Chambers, in early 2006, and all those with whom she was corresponding, knew that this problem, now admitted to be a software bug, had been around for years, in quotation marks. Horizon Support were telling the sub-postmasters whose branch accounts were affected by discrepancies that they cannot find any problem. The SMC, the part within Fujitsu responsible for providing corrective action for event storms, would not always notice these had occurred in time, and by then the damage may have been done. I find by quotation the damage that this can only mean impact upon branch accounts. Well, none of that, of course, was before His Honour Judge Havery. They pursued Mr. Castleton, and they pursued him as a precedent. And it is absolutely clear that the expenditure of $321,000 to pursue a debt of about $25,000 is utterly ludicrous as a commercial case. It ought to have been dealt with by financial controls. It ought to, we suggest, been escalated. It is a mark of the oppressive culture, and it is unconscionable that such costs were generated. Mr. Castleton, a litigant in person, did not even know that he could require their bill to be taxed. And so therefore he was saddled with that and remains saddled by that in bankruptcy. He did not even know. Nobody informed him that the bill could be assessed. It is an appalling and most discreditable episode. And it ought never to have been countenanced. I now come, if I may, to compensation. And I want to briefly deal, if I may, sir, with some of the thoughts that have been expressed and given in evidence before you about this. I will not refer to Mr. Castleton's evidence. He was nearly destroyed, but with tremendous courage, he now tells you that he is happy. But he's only happy because he's a person of profound faith and stoicism. And it is humbling that a man who has been subjected to so much, together with his wife and children, can reach that level of acceptance. I suppose basically it was submission. He was powerless to do anything in front of this juggernaut that crushed him. Nicola Arch, mentally, physically, emotionally broken, unending pain. She and her husband even considered committing suicide together. They now have a child, but after their child was born, she had a massive operative procedure, and she is beset with health problems, emotional and physical. Miss Felsted, who had to go somewhere else, out of the bosom of her close-knit family, leaving the area in which she'd grown up because of the shame. She asked in front of you, do they have children? What if it was their daughter? My 15-year-old son said to me last week that he's glad that he doesn't have the same surname as me. He sits in school and, you know, he hears people talking. He sees stuff in his school. They have TVs that project the news. He's happy that he doesn't have the same surname as me. I'd like for somebody to be held accountable. It's not just one person. There's not just one person that knew what was going on here. Somebody needs to be held accountable. I want them to sit here and feel what we feel. We're having to do this again. We're having to tell our stories over and over. We just need answers so that we can move on with our lives. And you know, sir, that she is now, as she has expressed, unable to take any further part in the provision of evidence. Mrs. Misra, the post office scandal made me feel this is a land of two law. There's a separate law for the rich and in authority, and then there's a separate law for people in the common people. And another thing, you know, like I'm really thankful for the inquiry, you know, so we can put a point forward. But at the same time, I don't want Post Office to hide behind the inquiry and saying that, okay, we'll make a decision when the inquiry is done. Inquiry going to find out who know what and what punishment they like, but they don't for whatever decision they need to. Whatever caution they need to answer, they should still carry on. Every time we go to court, we find a new evidence where there'll be a clerk advice, shredding document, and they were probably like some more coming up as well. Well, I've already referred this afternoon to the Altman documents. Can they be sincere for once, Mrs. Misra said, and say the truth and accept it, and to be honest? I say it for myself and probably the same for everybody, not just physically. We are mentally tired. We are mentally tired. We want to enjoy life, whatever we got left. Can't just it's not an easy thing, but that doesn't mean we're going to give up. We do want the answer. I just say, please get this sorted. Mrs. Skinner, Janet Skinner. There's too many people involved in what's gone wrong. Either it'll be within the government, the Royal Mail, the Post Office, the legal system, the defences, the legal teams. So many people that have wronged all these people and destroyed so many people's lives. We need answers from it. People think that we're here because of money, and people automatically think that all we're bothered about is compensation. The only thing that compensation will ever change is our financial stability. We've got a life sentence for what's been done. We will never erase the memories of what's happened over these past 20 years, and it won't. We've got to live with that. But yet, you get the people at the top who just basically say, I'm sorry, we made a mistake. You made a mistake by destroying people. Do you know, Seema was right in what she said. There's a split between them and us. So why is it that the people at the top think they have more power? What makes them above the law, above anybody else? If we break the law, we get penalized. They're breaking the law, and nothing comes from it. So, sir, I'm going to ask you to take the opening statement as read.
I should tell you that it has been read.
Yes. Well, thank you. There is no point repeating that which has been so ably addressed by all counsel who preceded me. You have our opening statement. But, sir, you know your august responsibility. You know it well. The best expression of sorrow or contrition is not a legally rehearsed and trite expression. It's not the tight body language of somebody sitting by their lawyer. It actually comes from acts, from deeds, from actually complying with disclosure deadlines so that we do not have, it would be trivial to call it a rigmarole, given the destruction it has caused, but the same monotonous, repetitive non-compliance, wrongdoing that has dogged this appalling episode in British history, British legal history, from the outset. These broken people trust in you, but they confide in you that you will go thorough and root out the truth, that you will not entertain any further excuses or rationalizations that were advanced before you on Tuesday of this week. And we respectfully submit, sir, that you are more than able and very well able to achieve justice for those we collectively, Mr. Steen, Mr. Maloney, and myself, represent.
Thank you very much, Mr. Henry. We'll now have our afternoon break, and then I think we'll hear the opening submission on behalf of the Federation. So I'll see you all in 15 minutes.
Good afternoon, sir.
Good afternoon.
I am Katrina Watt, and I appear on behalf of the National Federation of Sub-Postmasters this afternoon.
Thank you.
Thank you very much for allowing us to make this opening statement, which has been provided to you, sir, in advance. I intend to substantially read from it and comment and add as I go along. I also may call up some documents.
Certainly.
First of all, in making the opening statement, the National Federation of Sub-Postmasters welcomes the opportunity to assist the inquiry and its chair in any way it can, in order that the failings of the Horizon IT system at the Post Office and the miscarriages of justice in the prosecutions of postmasters and other Post Office staff which followed can be fully addressed. And I would just want to acknowledge, as counsel who spoke before me did, the detailed and sometimes shocking information provided in the opening statement of counsel to the inquiry, so clearly given. The NFSP appreciates that the Chair has had the benefit of already having its core participant status submission, also its statement on issues and evidence of the hearing on that in November 2021, when Callum Greenhow appeared before you. But notwithstanding this, the NFSP seeks to encompass the key issues for it by making this opening statement. The NFSP recognises the scale and importance of the work of the inquiry, and in particular the care and time taken by it to give voice to those affected through the human impact testimony sessions, and of course here with the statements that have been given by counsel on behalf of those core participants. The devastating effect on those individuals and their families of what happened to them as a result of the Horizon IT system and the operation of it by Post Office Limited was laid bare in those sessions. And while the NFSP has no direct involvement in the setting up or delivery in respect of the compensation scheme, In its written contribution to the inquiry's compensation hearings, the NFSP urged the Government and the Post Office to make interim payments to those affected without further delay. In this regard, it is the strongest possible hope of the NFSP that all of those who suffered as a result of Horizon and were wrongfully prosecuted and or dismissed will have their reputations restored, although, as we've heard, how difficult, if at all possible, that may be, and all of their financial losses, including consequential losses, refunded. In applying for and being granted core participant status, the NFSP is able to participate in and hopefully contribute to the proceedings in a way in which they could not, for instance, in the litigations which gave rise to the issued judgments of Mr. Justice Fraser, in particular Bates and others against the Post Office Limited, 2019 EWHC 606, Queen's Bench, Judgment Number 3, brackets, Common Issues, which discussed and commented on the role of the NFSP, and I will say a little bit more on that later. But this was because neither the NFSP nor any of its officers were asked by any of the parties to give evidence to the court, leaving Mr. Justice Fraser without the benefit of direct evidence on matters involving the NFSP and on which he went on to comment, such as those discussed by him in Part F of his Judgment Number 3. The NFSP recognises it is one of only a number of representative organisations, such as trade bodies, which the NFSP is, unions and others whose members were affected by the Horizon IT system and the actions of Post Office Limited in relation to it. And I think what I go on to say next, it is important because we have heard, of course, about many victims. There are also a number of organisations of which they may have been members. Only postmasters can be members of the NFSP. As a result of information obtained from a Freedom of Information request, and I understand that was from the journalist Nick Wallace, who has shone a light on so much that has gone wrong here, it is understood by the NFSP that of the 766 who were prosecuted, approximately 56% were postmasters, leaving the other 44% of those prosecuted as assistants and post office employees. This means a sizable number of prosecutions were brought against people who were not postmasters and therefore did not come within the ambit of membership of the NFSP or another trade body, such as the National Federation of Retail News Agents, the NFRN. And I understand that at least one of the core participants discussed in earlier submissions, for instance, was a member of that organisation. This, of course, actually makes it even more difficult, as I'll go on to say, to put the whole picture together by these organisations. There are several different representative bodies whose members were affected here. The NFSP considers it is important for the inquiry to encompass this wider group within its work and its ultimate findings in order to ensure that the public understands the reality of the risk which was faced and, in many cases, one which came to pass for anyone, not only postmasters, who worked in a post office during this period. This is because what happened as a result of the introduction and consequences of the Horizon IT system is not a postmaster-only issue. It is one which affected a wider set of employees of the Post Office. In addition, it's understood by the NFSP that many of those prosecuted were likely to have been members of other unions or trade bodies, such as the Communication Workers Union, the CWU. The NFSP understands and appreciates that the inquiry is aware of these different representative bodies and will be considering the roles, opportunities, actions in respective involvement, for instance in the working group, highlighting issues with Horizon and supporting their members. As well as assisting with giving evidence at the forthcoming Phase 2 of the inquiry's work, where two former senior officers of the NFSP will be giving evidence before you, sir, the Phase 2 of the inquiry's work on the Horizon IT system itself, the procurement, design, pilot, rollout and modifications. The NFSP sincerely hopes to contribute by way of giving evidence at the following phases. While the NFSP's role in the area covered by Phase 2 was more limited, it is true to say that it had more involvement in the areas covered by Phases 3 and 4, as well as also 5 and 6, and more will be said by the officers of the NFSP should they be called to give evidence in those phases before you, sir. As a representative body representing postmasters across the UK, and just to be clear in terms of comments made this morning in submissions by Council, postmasters are self-employed. They are not employees of the Post Office. And therefore, it's incorrect, as I'll go on to say, that the NFSP was on the side of or sided with the employer. Postmasters were self-employed, are self-employed. The NFSP considers it has a genuine contribution to make to the inquiry also in terms of Phase 7 on current practice, procedure and recommendations for the future. In particular, the NFSP remains concerned about the extent to which Post Office Limited is open to dealing with change which the NFSP believes is required. That includes governance issues, such as, for instance, whistleblowing, the concerns of postmasters, and dealings with the NFSP itself. I'll say a little bit more about that later on. In other words, as said by Callum Greenhow, the current Chief Executive of the NFSP, when he appeared at the hearing on issues on the 8th of November 2021, can a leopard change its spots? As he said on that day, if any of those responsible for the GLO strategy remain in post, is it possible for the relationship between those who own and operate and work in the Post Office network to be reset? Through the work and ultimate reporting of the inquiry, the NFSP wants to finally understand what went wrong and why. Although, as mentioned in the opening of Council to the inquiry, that has already now been laid bare in its detail. The NFSP both hopes and believes the fullness of the present inquiry and the commitment of the Chair to it will have a significant impact on the change which is necessary for all of those in charge, from government departments to Post Office Limited. This will include action to right the wrongs of the past and recommendations to ensure such a devastating scandal cannot happen again. In dealing with the various chapters for the NFSP, these will firstly set out the history and relationship of the NFSP with the Post Office, because if nothing else, some comment has been made, sir, in these last few days about that, and the NFSP wants to make it clear to you, sir, that it is, in fact, independent of the Post Office. Thereafter, the opening statement will consider the involvement and position of the NFSP in relation to the Horizon IT system, what it could do and what it did do in relation to it. That's in the earlier days with which Phase 2 is concerned. There will also be reference to the issues and the evidence it can give on the further phases of the inquiry, and its hope to provide recommendations to the inquiry, which will create trust in the systems of working and the relationships between postmaster, employees, government and the Post Office for the future. In closing these introductory remarks, the NFSP wants to make it clear that while it has supported many members over the years in disputes with the Post Office, and noting some of what was said by Council who spoke this morning, where there were any of the NFSP members who did not receive the help that they considered necessary, that will always be a matter of regret for the NFSP. But as I will go on to say, without the knowledge that it turns out Post Office and Fujitsu had, the NFSP was limited in what it could do. And it is, of course, with hindsight, with all of the information that is now available to it, that the NFSP and others can look and say, well, why did we not know this? If we'd known it, we could have done something. Much of what took place for the NFSP was done at local level. And as with other organisations, it's really only when it moves up the way and becomes collective that it's clear what the picture is. But that wasn't possible here, and we say that's because of how the Post Office was conducting itself. But the NFSP sincerely regrets that its belief in the Post Office Limited, the government, Fujitsu and the justice system was so misplaced, and we've heard comment on that from others as well today. The current Chief Executive and Board of the NFSP have expressed and continue to express considerable regret that more assertive action was not taken by its past leadership to challenge the Post Office in a way which may have prevented some postmasters from falling victim to miscarriages of justice. It continues to be a source of regret to the current leadership of the NFSP that for some of those postmasters who came to them for help in the past, they have had to wait many years to successfully defend their names through the general litigation. In participating fully in this inquiry and in seeking answers to pertinent questions from the Post Office, IT businesses and contractors, government departments and the criminal justice system, the NFSP can represent the interests of sub-postmasters to full effect. Looking at the NFSP as an organisation in order to understand what it is and where it comes from, it's an independent, professional, not-for-profit trade association representing post office operators, postmasters. The board of the NFSP is made up of serving postmasters who are nominated by their peers, bringing with them the understanding of the operation and running of post offices with all that entails. The history of the NFSP shows that it is a long-established body, established on Easter Monday, 1897, by a group of around 90 sub-postmasters who wanted to improve the conditions for all sub-postmasters in the UK. This was perhaps indicative of a historically strained relationship with the Post Office, and one might ask how much has in fact changed since then. The letter of invitation to postmasters read, "The importance of forming a national association is evident from the fact that whilst our conditions of labour have so little improved, the head postmasters, the clerks and the postmen have each obtained important concessions through their respective associations." The new federation secured official recognition in 1906, and in its early years, the federation was able to achieve some minor successes for sub-postmasters. It started organising an annual conference and the production of a monthly newspaper called the Sub-Postmaster. It is from there that today's NFSP represent members, that's postmasters, self-employed postmasters, who own and operate around 8,500 post offices across the UK, from inner cities to the remotest corners of the countryside. Notwithstanding this, though, the NFSP is actually a small organisation with just 26 employees. The current objects of the NFSP include, but are not limited to, regulating relations between sub-postmasters and the Post Office by negotiating rates of pay and conditions of service, variations to sub-postmaster contracts, participating in any form of consultation or negotiation relating to conditions of service for sub-postmasters, and endeavouring to settle collective or individual disputes between members and Post Office Limited, promoting such settlement through joint participation, conciliation or arbitration. Now, the status of the NFSP and its funding arrangements have changed over time. And we say this is relevant in respect of both the litigation that followed and how the organisation developed. Until January 2014, the NFSP was a trade union, but this status was removed when the Trade Union Certification Officer advised that the organisation did not meet the legal requirements necessary to be a designated trade union. In 2015, the change of status meant member subscriptions had to come to an end, and instead the Federation then received its funding from Post Office Limited, which consisted of a 15-year grant framework agreement, known as the GFA, paid annually, which is currently being renegotiated to ensure it is clear and that the NFSP can challenge the Post Office and that the GFA is made open and transparent. And of course that all arises from what I'm going on to say next. As a result of all of this, it was in October 2016 that the NFSP changed to trade association status following a membership vote. And just before I go on to look at the Common Issues judgment, I want to be clear that the NFSP is not beholden to the Post Office, nor is it afraid to speak out about the Post Office. And as I will show, the NFSP has at times, in its review, been misrepresented by the Post Office. And perhaps therefore others have come to the view that it is somehow siding with the Post Office on matters. In 2021, Judgment Number 3, Common Issues, Mr. Justice Fraser was considering the evidence of the Post Office in support of its position in the litigations. In particular, the evidence of Mr. Nicholas Beale that the NFSP allegedly did not support the litigation. No evidence was offered for that. In this passage of his judgment, apparently on the basis of Mr. Beale's evidence, Mr. Justice Fraser described the NFSP as not remotely independent of the Post Office, and then went on to focus on the GFA and the funding arrangements. Within the litigation itself and what was provided to him by the Post Office, or not provided as the case may be, he was concerned by the failure of Post Office Limited to make the GFA available in full to the court. In addition, Mr. Justice Fraser also discussed changes to the NFSP's website during the course of the court hearings, finding this to be suspicious because he had received no evidence from the Post Office as to why this had happened. As already mentioned, the NFSP were not party to any of this, and it must be said that Post Office Limited has no control over at all or say in the NFSP's website. All that had happened during this period was that the NFSP's communication officer was updating the website as to tone of voice, colour and location of content, and it had been decided that the GFA should be moved from the About Us section to another section where it appeared to fit better. The NFSP was entirely unaware of the way in which this would end up being interpreted in the ongoing court action, as it did not know this was an issue. As already mentioned, the NFSP was not a party to or called to give evidence in this case. It had no opportunity to correct the record or the way in which the Post Office put forward its position on the litigation or the GFA, or how some of these other comments that were made about it ended up being interpreted. As can be seen from the explanation of the development of the NFSP from trade union to trade association, it was funded by its members until 2015, when its trade union status was withdrawn. The Freedom of Information request I mentioned earlier showed that around 80% of the prosecutions with which this inquiry is concerned, took place between 1999 and 2010, with around 20% from then until 2015, and as we have heard this afternoon, with none after 2015, and Council who spoke before me set out why that was. The GFA was therefore not in place during the time of those prosecutions with which that litigation was concerned. There was no evidence produced by Post Office Limited about the position of the NFSP on the litigations. The NFSP has been and remains concerned about the reputational damage done to it by the way in which this was presented to the court by Post Office Limited and, as a consequence, discussed in the judgment without evidence from it. And the NFSP seeks to correct this at the inquiry, in particular in evidence at Phase 4. All of that being said, the NFSP wishes to make clear that it otherwise fully supports the judgment and the outcome from these cases and the way in which Mr. Justice Fraser dealt with those. It is concerned at the way in which certain evidence and material about it were presented to the court by Post Office Limited without an opportunity to correct the record, which resulted in the comments about it. Turning to Horizon, in the period with which this inquiry is concerned, there was a combination of a decline in footfall and income, changes to technology, changes in the way customers dealt with their money. In summary, this saw several cost-cutting exercises resulting in post office closures through what's called, or is termed, network reinvention in 2003, network change in 2007, and network transformation from 2012. But before all of this came, the need to introduce a network-wide IT system was clear, and the NFSP supported this, recognising it was necessary to secure the future of the post office businesses in the digital age. And can I add, the NFSP wanted to ensure a proper and fully functioning network of post offices was kept open across the UK. That was a major issue for the NFSP. As part of the research into Phase 2 of the inquiry, what has struck the current NFSP personnel is the number of prominent MPs from the last 25 years of British politics who, it transpires, were involved in the procurement, rollout and working group in relation to Horizon. The NFSP considers it is therefore important that the inquiry is able to establish their roles and responsibilities in how this whole affair led to so many postmasters, assistants and employees of the Post Office Limited having their reputations destroyed, suffer such financial hardship and in some cases endure a custodial sentence. In setting out some of the information which follows, the NFSP refers to events, meetings and in some cases documents which are records of meetings and issues arising from the procurement and rollout. So this really concentrates on Phase 2. In 1995, the NFSP's records show the number of system providers, as we heard earlier from Council to the inquiry, down to 3 companies, one of which was ICL Pathway. Of course, that then goes on to become Fujitsu in due course. Each of those attended an NFSP exhibition in Manchester where members were able to see the potential options available. So the NFSP were taking an active role on behalf of their members to find out about what was going to be coming forward. In February 1996, in a letter to the Executive Committee, the negotiating committee of the NFSP met with 3 companies and asked questions about certain matters. The ease of use of equipment, the impact on transaction times, acceptability to customers, the extent to which the design will help postmasters to prevent fraud, the extent to which suppliers' proposals guide the postmaster through transactions, proposals for training, the timescale for rollout, the extent to which the design is foolproof. What plans do they have for ongoing marketing? What plans for distant office transactions, agent encashment and change of office procedure? The NFSP did not express any preference in which system should be chosen, and indeed it was not technically equipped to do so. But it did have an interest in how such a system would work for their members. In May 1999, the NFSP were made aware that the DSS and the Treasury were considering pulling out of the Horizon project. And again, we heard about that in some detail from Counsel to the Inquiry in his opening. It's understood the DTI wanted the project to continue, and after intervention by Stephen Byers, the then Secretary of State for Trade and Industry, it remained on the table. The NFSP asks the inquiry if this suggests that there was discord between government departments which led to mismanagement of the project and or a lack of oversight, or that some departments may not have been working together. Can I add that in light of all that has been said by Counsel to the Inquiry over these last couple of days, what is clear now is that from the outset there were doubts and difficulties, and the NFSP has listened with concern to all of that. On the 14th of June 1999, the DTI report on the Horizon project stated, "We understand that the Benefits Agency failed to prepare itself and its systems sufficiently in order to be compatible with Horizon." The NFSP asks the inquiry if incompetence at government and departmental level contributed to the failure in the procurement from the start. In June 1999, the DTI Horizon project report says, and I should say, sir, that some of these documents have been provided recently to the inquiry by the NFSP, and therefore do not as yet have relativity reference numbers, and that may come in due course. I simply wish to let you know that.
Yeah, thank you very much.
While it makes evident sense for ICL to continue with the work it has already begun, the impression remains of an essentially political deal to ensure that ICL has a substantial contract with the Post Office at a price which seems to have been largely determined in advance of contractual renegotiations as a means, however inadequate, of making up some of the 180 million written off by ICL in their 1998-1999 accounts. Notwithstanding the documents referred to and available to the inquiry for the procurement exercise, the NFSP has found little to no evidence of its direct involvement in the procurement of Horizon. In terms of the rollout, the NFSP understands that the automation project can be traced back to around 1992, when the DSS began a trial of a new benefit entitled Claim Form, which omitted the use of post offices. Following extensive campaigning by the NFSP at that time, the claim forms were withdrawn. The concern from government was around the drawbacks of the paper-based methods of payment, namely cost, fraud, liability, and lack of customer-level accounting information. According to the September 1999 DTI committee report, slippage of the rollout programme began to occur and it was delayed. Similarly, the Montague report suggested that in 1997, a formal default letter was sent to ICL Pathway, who rejected it. That report went on to highlight that the rollout was unlikely to begin by the end of 2001 without improved management and uncertain costs. What happened next was the pilot scheme, and the pilot began on the 12th of April 1999 with 200 offices in the northeast and southwest of England being involved. These offices were a mixture of both Crown offices under the responsibility of the Communication Workers Union, while others were independent offices under the responsibility of the NFSP. On the 29th of April 1999, 113 post offices completed their first accounting, their first cash account via Horizon. And these offices were split into two groups, those who were supported during the balance and those who were not. And of those who were supported, 47 completed their cash accounts, while 23 did not, a figure that the NFSP found concerning. The NFSP was watching this pilot carefully in order to challenge the Post Office Limited, where ongoing results of the pilot showed the issues needed to be challenged, and also to support its members where needed. On 30th of April 1999, Pam Jervis, the late Executive Officer for the Midlands region, raised concerns about training and installation of Horizon. Now this, I'm going to, at least attempt to call up document NFSP 0000340. On the screens. And we move to the second page of this document, beyond the facts cover. Thank you. And it's noted at section 1. The first day of training is okay, but the second day is bad because it is rushed. They are not finishing on time, but they are rushing to finish before 3:30 p.m. because otherwise they have to buy lunch. Why did they use the most expensive hotels? Goes on to say, many sub-postmasters have not received assessment or certificates on completion of the course. In every training session, nobody had done a main balance. Nobody had been trained to do a full balance. The trainers are people who have only received the same training that they are giving out. It's too narrow a field, and no one can answer questions. If we continue on to the page that follows, scrolling down the way, and the paragraph just below the bullet points, she reports, in general, sub-postmasters are extremely happy. They think it's a great, sophisticated system, but it is being pushed out too quickly, and the people doing the training know no more than the sub-postmasters. There is no managerial backup, no definitive answers are given. What is needed is a system helpline. So that's back in 1999, with the comments coming as part of this initial pilot. So things are being picked up and commented on, and then being fed back by the NFSP to the Post Office. I can take that document down now, thank you. In June 1999, the NFSP prepared questions for Stephen Byers, the Secretary of State for the Department of Trade and Industry, and Stuart Sweetman, the Managing Director of Post Office at that time, about training, modification, migration, operations, balancing, the help desk and barcoding, all due to the issues that have been raised from the pilot, some of which were highlighted in the document just shown there. On the 14th of June, the NFSP appeared before the DTI Select Committee. The chair asked if the NFSP was being alarmist in suggesting that thousands of post offices were threatened by closure. At question 6, Colin Baker, then General Secretary of the NFSP, and I appreciate, sir, that you'll be hearing from him later in this phase, was asked, do you really think that there has been anything more than lip service being paid to the concept of sustenance of the network of sub-post offices being kept going by the Horizon project? Mr. Baker replied, I think it's easy for successive governments to make a commitment to a nationwide network of post offices and yet not be in any way specific about what is meant by that. And the NFSP says that is as true today as it was in 1999. At this DTI Select Committee, the Communication Workers Union and the CMA explained they had a valuable role to play, not only in protecting members' incomes and security, but also in protecting public interest. They highlighted that the Crown network represents 15% of the total volume of the transactions in the network. They emphasised that the Post Office could deliver the project, but raised concerns about the commitment of the government to the network. They explained that without commitment from the government, the business would be in a downward spiral. On the 30th of June 1999, there's a briefing to Colin Baker of the NFSP, and I'll call up another document, sir. NFSP 00000027. I hope I've got that correct. And again, we'll go beyond the facts cover page to the next page. Now, this is a personal briefing note to Colin Baker of the NFSP, and it's from Liam Foley, who was the Business Development Director. And you see that at the top of the page, ICL Pathway. Now, that third paragraph down begins offices. Offices have experienced problems with the balancing process, both in stock unit balancing and the cash account. There have also been printing problems. We've taken these problems very seriously and are making significant effort to improve the situation for the sub-postmaster. And then he goes on to talk about what actions he's put in place as a result of the NFSP's points to him. And there's a set of bullet points there setting out the system changes that are going to be made, major changes in the manager's training course, major work being undertaken to ensure that all document is at the same level as the system, and a task force in place to identify the specific nature of the printing problems. Now, from the NFSP's perspective, what is happening here is that the points that it is putting to those in charge of Horizon from its members are being taken on board. That's what it thinks is happening. If we go on to the next page, please. Mr. Foley then goes on to tell Colin Baker, you may be interested in some specific feedback from one of the offices visited last week. The postmistress commented that this was the second week in succession they had balanced more quickly than they would have done using the old manual method, even allowing for the minor glitches. Whilst they were commenting openly on how difficult they had found balancing and that they had raised many objections, they freely admitted that it might be easier for them if they had followed the quick guides and manuals. They now have little fear of the system and are starting to better appreciate its benefits. And he then goes on further down the page, in the final paragraph, I believe it is very important that a positive, constructive perspective is maintained by us all. I know I can count on your support to achieve that. I will, as ever, be happy to listen to any specific feedback from the Executive Council. Thank you. I can take that document down now. As I said, what the NFSP was thinking was that Pathway and others were taking on its feedback, hearing that changes were being made and that the system was being improved and it would be fit for purpose. On the 10th of August 1999, the NFSP held a special Horizon meeting in Newcastle with over 150 postmasters in attendance. This is all part of the early days of the introduction and the pilot of Horizon. Dave Miller of the Post Office was in attendance, along with Jean Kendall, the National President, and Colin Baker of the NFSP. Dave Miller and Colin Baker highlighted that automation was the future for postmasters. The concerns from colleagues who were part of the pilot were highlighted, and these included the stress on the workforce, the strain on people's lives and marriages. There was enforced cancellation of planned holidays. There was low additional income provided by the Post Office to postmasters who were on the trial. On this point, these rates had not been agreed with the NFSP, but brought in by the Post Office, and the NFSP were able to ensure that those payments were doubled. Those on the pilot also raised concerns that the installation project lacked management at every stage, and highlighted the number of reboots of the system that was required, especially on balance day. Now, here I'll call up NFSP, that's 0000237, please. And if we can scroll down just to the bottom half of that page, please. You'll see the general points that I have just mentioned were being made, agreed by all on the trial. The stress on the workforce, strain on people's lives and marriages, lost holidays, the small amounts paid by Post Office Counters Limited as it was. Of the 44 Horizon officers present in a vote, 30 officers said they suffered stress. If we can go on past the next page to the final, the next 2 pages to the final page. I think we scroll down. I'm sorry, that's me. If we can scroll back up to the bottom part of the previous page. So the last 2 paragraphs of that page. At the end of the questions, Dave Miller summed up the evening and asked one question: should he authorise the national rollout? All officers agreed there was nothing fundamentally wrong with the system. However, they did not want to roll out until further improvements had been made. And on the final page, I don't need to turn to it, it's there simply that there was a request for urgent training. Urgent provision must be made for training reliefs, that's relief workers, because without training for those relief workers, the postmasters themselves could never be away from the post office. Now, I highlight all of that to show simply that in the pilot and the rollout phase, there were points regularly being made by the NFSP to Post Office and to ICL. Of course, it could not have been known at that time what was to come. From the NFSP's perspective, what is clear that throughout the rollout of the Horizon programme, the NFSP supported colleagues where they could and challenged the Post Office on behalf of the network to improve. In June 1999, after concerns were raised by the NFSP over the quality of training, the Post Office invested a further £8 million to improve the training programme. These improvements arose from the points raised by the NFSP as outlined in my earlier paragraph. For the NFSP, this all provides clear evidence of their headquarters helping colleagues across a multitude of areas during the rollout. That's prior to the full implementation and all that happens subsequently. The NFSP would ask the inquiry to consider where the losses occurred in the cases, and the figures that I go on to give are a breakdown of examples as submitted by the NFSP to the inquiry. Simply have them there for illustrative purposes. But what those figures show is that where members were contacting the NFSP at a national level for help, internally the Post Office was being challenged. However, that does not mean that in every case the outcome that the postmaster wanted was achieved. It also shows that not all issues were software or branch accounts related. For example, the 200 cases of REMs, counterfeit and fraud in the main focus on a number of fraudulent gyro checks that were being cashed at post offices in the mid-2000s. This resulted in many transaction corrections being issued to postmasters by the Post Office, which were subsequently overturned after intervention by the NFSP. Others involved hardware such as computer screens, printers or base units not working. Moving on to touch on the working group, the NFSP considers that it is important to note that the working group, which had been set up by the government to seek to involve interested parties on the decision-making process, consisted of the government, the Post Office, the CMA, the CWU and the NFSP. The NFSP considers, therefore, it will be important for the inquiry, of course we already just heard from Council who spoke before me regarding the terms of reference, what the involvement of each of the three representative bodies did on the working group. Throughout June 1999, there were issues arising with Horizon which the NFSP were aware of. For instance, a fax from Fujitsu to NFSP outlined software changes due to postmasters finding the balancing process difficult to follow, unnecessarily restrictive and time-consuming, and this was discussed at a balancing workshop between the Post Office and Fujitsu on the 11th of May 1999. One particular issue was a data entry errors during migration. There was a recognition that incorrect figures were used at migration to Horizon, resulting in a mismatch between payments and receipts. As a result, a change in the MyMan software was proposed at migration to ensure the correct figures were transferred over. Any mismatch would be highlighted with a warning at migration. On the 8th of June 1999, the first working group meeting between Government, the Post Office, CWU, CMA and NFSP was chaired by Ian McCartney MP, Minister of State at the DTI. At this meeting, terms of reference were circulated, and these included, I set that out, overseeing negotiations between Post Office and ICL, facilitating solutions to the development stage of the Horizon project, maximising the commercial potential of Horizon, concerns by the group the government did not come out of recent developments in a good light. Payment for Horizon would be about 550 million, paid with an initial 68 million and then 4 payments of 120 million. And 480 million would come from the Post Office liquidated assets, with the remaining coming from its working budget. And there would be potentially a further 400 million of cost to ICL Pathway, which would be part of the Post Office's future commercial challenge. There's then a second meeting of the working group on the 22nd of June, and we can see from that there is attendance from Ian McCartney of the Minister of State, as mentioned, representatives from the Post Office, Derek Hodgson of the CWU, Tony Cairns, CWU, Terry Deegan, CMA, Tony Harris, CMA, and Colin Baker and John Perbody of the NFSP and others. As can be seen from the minutes of that meeting, there was discussion around the removal of the benefits card from the process. And from the NFSP's perspective, it appeared that ICL were preventing the Post Office from seeing exactly what they were buying. The NFSP notes from the time was that there was a general discussion from all parties in relation to costs, around 80 million per year, and the Post Office's ability to afford the system. With the loss of the benefits payment card, there was a question if there was sufficient business to make the whole system financially viable, with negotiations between the Post Office and the Benefits Agency apparently not going well, as it appeared there was a financial gap of around £400 million. On the 11th of October 1999, the fifth meeting of the working group took place, and this had representatives from the DSS, the DTI, the NFSP, the CMA and the CWU. And at that meeting, the NFSP was raising concerns about the Benefits Agency trying to encourage benefit claimants to move to the bank, despite the NFSP having understood there was a commitment not to do that before 2003.
So I hesitate to interrupt whilst Ms Watt takes a pause in her submissions. The Federation submitted a time estimate of 30 minutes for their submissions, and we've been going for just under an hour. It didn't feel as if we were reaching a point of winding up from the pace and tone, and I wonder whether I'm correct in that assumption. It's 4:30 now, and I interject to give you the opportunity to give some direction as to the way forwards.
Well, I've been following the submissions, and unless there is to be substantial additions to the written statement, in fact, we're about 3 or 4 paragraphs from the end. But maybe I could be enlightened.
That's correct, sir. I am literally almost at the end. I do apologise for the overrun. I'm grateful.
An unnecessary intervention then, I'm sorry.
No, that's fine, Mr. Beard. It's always good to be rigorous about these things, but I did presume that you were reaching the end.
That is correct, sir. Just by way of going slightly off script, I do want to touch on comments made by Council to the inquiry yesterday, where he picked out comments of George Thompson of the NFSP at the Bays Select Committee of 2015 regarding the system being robust, and simply wanted to add, although I don't have the document reference for the Bays 2015 Select Committee with me to hand, but simply to note that elsewhere at that same Select Committee, the CWU's representative had said that the Horizon system had served the community and the wider electorate well. By definition, there will always be bad apples in the barrel, and it's a robust system. I simply wanted to draw that to your attention, sir. In conclusion, on the forthcoming phase 2, the NFSP has reviewed a series of meeting minutes and DTI reports and has concluded that at the early stages there were concerns about the finances of the project, the rollout and the issues identified throughout the pilot, and matters underpinning the whole operation, for instance, the changes in relation to benefits payments. The NFSP recognises that it is for the inquiry to review documents, hear evidence and reach its own conclusions. However, the NFSP considers that from the outset, at the procurement stage through to the rollout, there were identifiable issues. It had a role in raising these issues and seeking resolution of them, and did achieve extra funding for training and other changes as outlined. All of that said, it is clear that what is known now is that there were significant issues and failings, and ultimately the Post Office chose to prosecute postmasters and others rather than face what was clearly a problem following the actual introduction of Horizon throughout the network. In closing, the NFSP repeats something said at the beginning, that it regrets sincerely that its trust in government, the Post Office, IT businesses and the criminal justice system was so misplaced. The NFSP sincerely hopes that the inquiry can illuminate in full all that happened, what went wrong, how and why it happened, and to ensure that it can never happen again. Thank you, sir, for your time this afternoon.
And thank you for your submissions. So, Mr. Beer, can I just check with you that we're due to start again at 10 o'clock tomorrow morning, and that unless I am very liberal in my approach to overrunning, we are due to finish at about lunchtime?
Both of those things are correct, sir, yes.
All right, then we'll meet again at 10 o'clock tomorrow morning, and thank you all very much.
Thank you very much indeed.